Hello and welcome everyone. Today we are going to take a look at two decisions from the UK, which are both have been delivered in the same case, in the same dispute. And the overall topic is the issue of interim licenses. So this were the two cases where the courts in the UK for the first time addressed this question whether it is necessary or under which condition it could be necessary for a patent owner to grant an interim license to the implementer until the courts will move on and set the terms for a final front license. So these are the two cases here. We have, again, two decisions. The first one is the decision of the High Court, which is the decision in the first instance. And then we have also the decision of the Court of Appeal, which followed after the parties appealed the decision of the first instance. So we're going to take a look at both of them today, with a focus, of course, more on the second decision, which is the final one in these proceedings. Now I'm going to go through the background of the case, of the dispute here, and especially the procedural history. So what happened before the courts, because this played a very key role to the decision of the court here. So especially in this case, the facts played a very important role. The decision was very fact specific. So it's really very important to keep that in mind and to look at how these proceedings evolved and how this litigation campaign moved on. It started in the end of July 2023. Then at that time, Panasonic filed cases against Xiaomi in different jurisdictions. We had proceedings in the UK. These are the proceedings we're talking about today. But at the same time, the litigation campaign was a bit broader. There were also cases filed in Germany. There were 3 lawsuits in Mannheim before the District Court of Mannheim. We had another 4 cases brought before the District Court of Munich. And apart from that, Panasonic filed also cases before the UPC, going to the local division in Mannheim and later on also to the local division in Munich. So these were the parallel proceedings that were ongoing more or less at the same time. In the UK, what Panasonic did was to ask the court to seek declaration that 4 UK patents have been infringed. Then also declaration that the terms that Panasonic had offered to Xiaomi had been infringed. And alternatively, if the court would not make that declaration, the court was asked in the UK to determine which are actual front terms for a global license. In the proceedings in the UK, relatively soon after they started, we had a discussion of whether the parties would commit to the front determination of the court, which Panasonic had sought. And in November 2023, both parties, not only Panasonic as the claimant, but also Xiaomi as a defendant, made undertakings towards the High Court to enter into a court-determined license. That would be the final outcome of the UK proceedings. Maybe here, just for our background, what is this undertaking? This is something which is legally binding and has, let's say, a strong force because it is enforceable, and it's also something that can have something similar as a court order. So it's a very important undertaking to make before the court. These 2 undertakings were made. Panasonic did not make a further going undertaking, which was not to enforce any potential injunction that would have been granted in Germany or by the UPC in parallel. So there was some discussion of whether Panasonic should add this element also to their undertakings, so focusing more or less on the UK proceedings and basically promising not to enforce any injunction that it would get eventually in the meantime in Germany or before the UPC, before the front determination was there. But Panasonic had chosen at the end not to make this undertaking. The reaction of Xiaomi was to file a motion for an interim license declaration. This is how I'm going to call it now. We're going to see in a moment what exactly was the content of this motion. But basically, the idea was here to ask the court in the UK to make a declaration that someone, a licensor, which would be in the position of Panasonic, would grant an interim license to Xiaomi until the court in the UK would make the final front determination. So this was the motion which Xiaomi filed in response to the fact that Panasonic did not commit not to enforce any injunctions granted in Germany or in the UPC. Then Panasonic made what the parties called a non-enforcement proposal. This was made in January, shortly after this motion was filed, and it was then revised in April 2024, which basically was a proposal to say that an injunction granted in Germany or by the UPC would not be enforced if Xiaomi would take a final license on the terms sought by Panasonic and pay the full lump sum for the whole period that Panasonic sought, and would then be entitled to get any refund if the court would make a front determination which would be more favorable to Xiaomi. But in this case, this non-enforcement proposal, based on this non-enforcement proposal, Panasonic would basically not enforce injunctions in Germany if this license would be taken by Xiaomi. Xiaomi did not agree with this non-enforcement proposal, so the proceedings went on. And with the first decision we're going to see today, in July 2024, the High Court dismissed Xiaomi's motion for an interim license. So it did not follow what Xiaomi wanted. This was, of course, a reason for Xiaomi to appeal this case, which then moved to the Court of Appeal. During the proceedings before the Court of Appeal, there was an interesting development in the sense that Panasonic made a new offer, an amended offer to Xiaomi, which was also lower, on lower rates. So according to the court, the offer, this amended offer, was 62% of the lump sum which Panasonic had sought before. Now, this just keep that in mind, because the court mentioned that in its reasoning in a certain aspect. The proceedings went on, and in October, so this amended offer was not accepted either, and the proceedings went on. And in October 2024, the Court of Appeal reached its decision, and it basically overturned what the High Court had said in the first instance and granted Xiaomi's motion. So these declarations that Xiaomi sought were basically okayed by the court and were granted. This did not lead, however, to a conclusion of an interim license, because Panasonic had declared already before any declaration was made that it would not grant an interim license, and it did not anyhow. So what was then pending in the UK was the actual front determination, which was scheduled to start in the end of October 2024 and to be done until the beginning of 2025. But this did not happen either, because in January 2025, the parties settled and they entered into a license agreement, which means that this case is, of course, very unlikely to go any further here, that the judgment of the Court of Appeal on the interim license application that we're going to discuss today is the final judgment in this case. Now, these are the facts, and let's now take a look at the first decision, which was delivered in the 5th of July. And here, the court had to decide whether this application, whether this interim license notion makes sense, and whether this application can be granted or not. And we had basically two elements that were examined here. The most obvious one was whether there is a reason to grant this this license, this declaration. So I'm going to go through that in a moment. And the second one was what is the purpose of that? Does this fulfill any sufficient purpose? But before going into the details, let's take a look at what was actually the ask of Xiaomi in these proceedings. What Xiaomi sought was a declaration that a willing licensor in the position of Panasonic would agree to enter into and would then in fact enter into an interim license pending the determination of what terms are front for a global final license by the UK courts. So these were the elements of the declaration. The court was asked basically to say or to confirm that someone in the position of Panasonic would enter into an interim license until the UK courts have set the final terms of a front license in these proceedings. Maybe one element which is important here to keep in mind is what is this declaration about, because there is a difference between a declaration and, let's say, an ordinary judgment or an order by the court, which basically orders a party to do something or not to do something. Here we have a declaration which is a bit different, meaning that the court is asked to, if we put it very simple, say what is the correct legal analysis, what is the right way to do something, but does not give a specific order to a party to actually do what is thought to be correct in legal terms. So this is important to keep in mind, because this also played a role in the analysis of the court here, especially the second part we're going to look at in a moment. So this was a request to have this declaration so that the court, the High Court, would confirm that Panasonic, if it would be held to be a willing licensor, would enter into an interim license with Xiaomi until the UK court made its final front determination. Now, this, of course, opens mainly two questions. There were some other elements discussed in the case, but let's focus on these two topics. The obvious one, as we mentioned already, is there such an obligation at all from a legal perspective? So is Panasonic or is an SP owner obliged in a way legally to grant an interim license? This was the first part of the analysis of the court. And then the second question is, if this declaration would be made, would this serve a useful purpose? Would it be good for something? Because here, just to remind ourselves, the declaration itself would not change anything. So the declaration would not oblige Panasonic to grant a license, or would not substitute a license, an interim license between the parties. So what is it good for? And if it's not good for something, then is this worth granting? That was the question in other words here. So the court looked first, is there an obligation at all to grant an interim license? And found that there is not an obligation, and also found that Panasonic had not really violated any obligations under the front commitment that it had made by pursuing in parallel the proceedings in Germany and before the UPC. So this was the main point of concern here, of course, because we said Panasonic had not given this undertaking not to enforce an injunction potentially granted in Germany or by the UPC. And here the question was, is this something that is it okay? Is it something that is in line with its front commitment? Or is it something that Panasonic should have not done and then would, on the contrary, have been required to drop these proceedings and then enter into an interim license? And the court said here, by pursuing the foreign proceedings, Panasonic did not act in bad faith. So it did not see that there is an obligation here for Panasonic not to do anything else rather than following the UK court proceedings that it had initiated. And in doing so, the court focused particularly on the contractual side of things here, looking at the ETSI front undertaking and trying to construct this under French law, which is applicable. Why? Because we have seen that the ETSI IPR policy is subject to French law, so the front undertaking that the ETSI IPR policy sets up is also to be interpreted based on French law. And what the court said here is that under French law, if you look at the front commitment, it imposes an obligation of good faith behavior. And this obligation to act in good faith means for a patent owner that he should act in a way not to frustrate its front commitment. So this is how, which is standard it basically. So you have made the front commitment, and under this front commitment, you have an obligation to act in a way, in a good faith manner, in order to basically fulfill the spirit and the purpose of the front commitment. And the court said here, if you exercise rights that you have as a patent owner before the competent courts, this is not an attempt to frustrate the front commitment. And that's here basically the conclusion of the court. Interestingly here, the court said that whether your acts frustrate the front undertaking or not is something that needs to be determined from an objective viewpoint. So what the party itself thinks, whether, for example, it thinks that the way it behaves meets the front obligations that it has under the front undertaking is not decisive. In the present case, it was accepted by the court that Panasonic believed that the way it behaved and the way it pursued the proceedings also outside of the UK was in line with its front obligations. That was also not disputed by Xiaomi. But the court said even if this subjective belief was there, even if the patent owner believes that this was there, this is not the end of the inquiry. So you need to look also from an objective perspective whether the good faith behavior was there. And again, the court said here that it could not establish with a high degree of assurance that pursuing the foreign proceedings would frustrate the front undertaking here. This high degree of assurance was a topic that was discussed also in the appeal. We're going to talk about this later on, but it was not, let's say, the key element here. The most important part is that the court did not see that the proceedings in Germany or the proceedings before the UPC can basically act or result in a delay or result in effects that would not be in line with the front undertaking and the promise that Panasonic had made towards ETSI. One reason for that was that the court did not believe that the foreign proceedings would necessarily result in super front rates. And also the court did not see a significant risk that the proceedings in Germany or the UPC would lead to rates that would be above front. This was a large part of the discussion before the court here, because the argument was basically to say that, look, if you're going to Germany and if you look at the German courts and how they approach front cases, there is a likelihood that you will end up in an injunction without a full examination of the patent owner's offer. And this puts pressure on the implementer to maybe accept terms that would go above what would be front in a specific setting. And the court looked into these arguments very much in detail. It heard experts of German law, of how litigation works in Germany and what the courts do and what the courts do not do. And at the end of the day, it found that there is no real risk that going through the German proceedings, you you would be forced to enter into licenses on super front rates. So the result was here that the court was not able to accept, or if you want to say it otherwise, Xiaomi was not able to persuade the court that Panasonic, by pursuing the foreign proceedings, had been holding out for terms that were obviously unfront or suprafront. So this was the part where the court tried to construe the obligations under this good faith viewpoint. And having said that, the court also added here that there is also no implied obligation to grant an interim license that arises out of clause 6.1 of the ETSI IPR policy. So the clause 6.1 of the ETSI IPR policy, just a brief reminder, is the provision which establishes the front undertaking that a patent owner shall give with respect to patents that are potentially standard essential. So here we had on the first step looked at what is the, let's say, the obligation of good faith and how this can be matched with pursuing proceedings outside of the UK in the specific setting. This was the first part of the analysis. And then the question was, is there at all an obligation to grant an interim license? Can you construct such an obligation from the front undertaking? And the answer to that was clearly no here. So the court found that it is impossible to imply an obligation to grant an interim license from the express words of clause 6.1, because this provision, in the eyes of the court, establishes only an obligation to make an irrevocable offer on front terms which is capable of acceptance, and there is no immediate obligation to grant a front license. So that was here also this part. The conclusion overall was that there is no real ground for making this declaration that Xiaomi sought, because there is really not an obligation to grant a front license, and Panasonic did also not behave in a way that an unwilling licensor would have behaved, which would be a condition to make the declaration sought here. Finally, the second part was then the question whether this declaration serves a legitimate, useful purpose. And this is a condition that needs to be met if you want to have a declaratory judgment. This is something which is important in this respect, because as we have seen or said already, a declaration does not really change things legally, because it does not oblige a party to do something, but it just gives, let's say, a confirmation by the court that a specific view is correct on legal terms. So you have to ask yourself, if we're not really having this impact which a court order has, what is the reason for making the declaration? And here the court could not find any reason that would basically justify making the declaration that Xiaomi sought. So the court rejected here that this declaration would serve a useful purpose. And it did not only say that, it went a step further by saying that it would not only a useful purpose was not only missing, but granting this declaration would be an exercise in jurisdictional imperialism. Why? Because basically the courts in the UK would intervene in a non-accepted manner with the jurisdiction of other courts, in the present case, the German courts or the UPC. So on the one hand, the court said here, there is no need to clarify the parties' rights and obligations in the present proceedings or to preserve the integrity of the UK proceedings, because on the one hand, you have both parties already committed to the front determination of the court. In this sense, whether they have fulfilled their obligations and rights is not is of secondary importance, because they would in any case be bound to the front determination that the court is going to make. And this front determination would also be retrospective. So this means on the one hand, it's not the most decisive part of how the parties behaved and what the parties should and should have not done, because they will get the front terms they are entitled to at the end of the proceedings. And on the other hand, by having committed to the termination, it is clear that these proceedings are going to take place, and that you don't need to take additional measures to make sure that the parties are going to follow the process and follow the court until the final front determination. So this was the one reason why the court found that there is no useful purpose in doing the declarations that Xiaomi sought here. And the court also said that if you look at the setting as it is here, the only real purpose of this declaration was to influence the outcome of the foreign proceedings. So it's not only that it would not serve anything with respect to the UK proceedings, but it would rather have an impact on the German and the UPC proceedings, which the court here considered that it's not a legitimate purpose. And the main idea behind that is to say that, look, if Xiaomi wants to rely on an interim license as a defense, which at the end of the day was what Xiaomi was trying to do here, because if you would have an interim license granted or an interim license in place, then of course this would fend off every claims for injunctive relief coming from an infringement of the patents, because you would have no infringement anymore. So this, the court said, this could serve as a defense against a claim for injunctive relief, against an infringement claim. So if you want to use that interim license notion in this context, the obvious place for raising the relevant arguments are the foreign proceedings. And from the viewpoint of the UK court, the High Court said here that committee would require the decision on this matter to be left to the assessment of the foreign courts. So committee, a buzzword here that was used, and we're going to see in a moment, also was part of the analysis of the appeal court. But at the end of the day, the court felt here that these declarations, if they would be made, would basically take part of the decision from the German courts or from the UPC, and in terms of committee, in respecting the jurisdiction of the other courts, the courts in the UK should not go so far and make the declarations here. So this one, did Panasonic violate the principle of good faith under its front undertaking by pursuing the foreign proceedings? If you remember, the court in first instance had said no, but the Court of Appeal said yes, that Panasonic was in violation of its front commitment. What was interesting here, and I'm going back to what we said in the beginning, that this decision is very fact-specific, is that according to the Court of Appeal, the key factor here for reaching this conclusion, so the main element, was the fact that in the view of the court, in this case, it is certain that the parties would sign a front license in the relatively near future. Why is that? Because we had, on the one hand, Panasonic seeking the UK court to make a global front determination, and then we had both parties making the undertaking to accept the court-determined final front terms. And according to the planning at that moment, when the Court of Appeal delivered its decision, the front trial would start relatively soon, because the parties had also agreed to move with the front trial first before going into technical trials and looking at validity of infringement of patents, etc. So it was expected that the front determination would eventually be there in maybe 3 or 4 months. So the court said here, if you want to assess Panasonic's behavior, you have to come as to use as a main aspect, as a key factor, this fact that in this case, it would be certain in the eyes of the court that the parties will sign a front license in the relatively near future. And using that as a main premise, what the court then asked itself is, well, if it is clear and it is sure that the parties are going to sign a front license relatively soon, what is the purpose of Panasonic for pursuing the foreign proceedings in Germany and before the UPC? And in the view of the court, the objective was to achieve better terms than those that would be determined by the courts in the UK. So to put it very simply, the court said the only reason why Panasonic continues with the cases in Germany and before the UPC is because because it wants to have a front determination, but it's just because it wants to get a better deal than what the UK court is going to set. And in this context, there was the argument that, of course, Panasonic brought, most likely that it wishes, of course, to pursue the proceedings abroad because it wishes to also reach a settlement earlier than the final front determination in the UK, which, if you would also count potential appeal proceedings, would maybe take years. But the court was not very much convinced by this argument that the foreign proceedings could lead to an earlier settlement, because it said, well, at the end of the day, France will be determined when these proceedings in the UK are done. And you have the opportunity to make a settlement anytime during the UK trial. So I did not see any, let's say, added benefit of having parallel litigation abroad as well. On the contrary, what the court again mentioned here is that it found that it was wholly inconsistent to further pursue the trials in Germany and before the UPC, and at the same time having sought global rate setting in the UK and having committed to accept the outcome of this global rate setting. So this was here the criticism that the Court of Appeal had on Panasonic's side. Then what the court also added here was to say that any rational SEP holder in the position of Panasonic would agree to enter into an interim license because Panasonic would be paid sooner than later. And again, the court here said you would get the money sooner than if you would wait to have an agreement signed, a final agreement signed. And if you don't want to do that, or you are reluctant to get paid sooner than later, then in the view of the Court of Appeal, the only reason for that was because you want to secure more favorable terms than what the court in the UK would determine. So as a result, the conclusion was that the way Panasonic acted, it did not comply with an obligation to negotiate the license with Xiaomi in good faith, because it failed to basically commit to comply with its front commitment, considering especially what the court said here, that front is also a process and not merely an endpoint. So it's not just front are not just the final terms of a license, but also the way you behave until you get there. And this was something that Panasonic failed to fulfill here, because it did not act, it did not negotiate in good faith in the eyes of the Court of Appeal. Now, what was interesting here is that Lord Justice Phillips had a different view on that, and basically he questioned that the front undertaking gives rise to an obligation to grant an interim license during negotiations or during the determination of front terms by a court. Because, again, it did not see how you can construe the front undertaking in a way that you could extract such an obligation. And in this sense, the opinion of Lord Justice Phillips was very similar to the view that the High Court had taken in the first instance. If you remember, the High Court had also basically refused to see any obligation to grant an interim license arising out of the front undertaking given to EWHC. And at least this corresponded with the view of Lord Justice Phillips, but the rest of the judges had a different view here, and that was what counted. So at the end of the day, what the Court of Appeal accepted was that Panasonic did not comply with the obligation to negotiate a license with Xiaomi in good faith, exactly because they kept pursuing the proceedings in Germany and before the UPC. Then the next question was the same one that was posed in the first instance. Would this declaration sought by Xiaomi serve a useful purpose? We have seen the court in the first instance said no. The Court of Appeal said yes. And here, what would be the useful purpose? Of course, the useful purpose would not be that the parties would enter into a license agreement which would basically give peace, at least until the final front determination. Because if you remember, we said already, it is about a declaration. So the court, the decision is not an order that Panasonic needs to comply with and needs to therefore grant an interim license. It is a declaration that it should do so. And Panasonic had clearly said here that it would not grant an interim license, irrespective of the decision of the court. So it was clear, or it was very likely that the declaration would not lead to an interim license. So what would be the purpose of doing such a declaration here? The Court of Appeal found that the purpose, or the useful purpose, was that Panasonic would be forced to reconsider its position not to grant an interim license. So it was clear that the declaration would not force Panasonic to change its views, but the Court of Appeal believed that there is a realistic prospect that the declaration will do so. And interestingly, it referred here to the fact that Panasonic had changed its mind before, referring to the offer that Panasonic had made in September 2024, which was on lower terms than the initial offer that it had made. So here the court basically said if they changed their mind regarding the terms that they offered to Xiaomi, then they might change also their mind regarding whether to grant an interim license or not, if this declaration is granted. And what the court also saw different here with respect to the first instance was that the declaration would also preserve the integrity of the UK proceedings, meaning that it would help motivate the parties to go through the front determination in the UK and also grant a license or sign a license based on the front determination in the UK. Because the court saw here that or thought here that Panasonic's objective, especially by also pursuing the proceedings abroad, was to ensure that no front trial takes place in the UK and that the court-determined terms, that the license would not take effect based on the court-determined terms. Interestingly, here we had again a different view by Lord Justice Phillips, because he looked at what would happen if this declaration was there. And of course, he also saw that the declaration would not lead to a license, to the signing of a license, interim license. But but Lord Justice Phillips said also, even if you would grant an interim license, the effect would be only transitory, as this license would basically need to be adjusted anyhow upon the final front determination by the court. Either you would need to pay money back, or you would need to pay more money. But in any case, it would not be a final resolution. It would not have only this transitory effect. So it questioned a bit here the real reason for making this declaration. On the contrary, here, Lord Justice Phillips followed the view of the first instance court, which was seeing in this declaration the real purpose and effect of this declaration to influence the foreign proceedings. So here, again, Lord Justice Phillips had a different view of whether this declaration serves a useful purpose or not. Then, very briefly, we had the question of comity. We mentioned that before. So should the decision not be granted, should this declaration not be granted in order to respect the jurisdiction of the other courts, of the German courts and the UPC? The court in first instance said yes. The Court of Appeal said no, there is not reason of comity here that would prevent us from granting this declaration. Why? Because the Court of Appeal said if Panasonic grants the interim license based on the declaration that we make, then comity is not hurt. On the contrary, it would be promoted, because the foreign courts would be relieved of a great deal of burdensome and wasteful litigation. On the other hand, if Panasonic would ignore the declaration, there would be no impact on the foreign proceedings, according to the Court of Appeal, because the German courts or the UPC would still be able to make their own assessment of the parties' conduct, and there they would also be able to include the conduct of the parties during the UK proceedings. So it did not see any impact in this sense that would require the courts to preserve comity and not grant the declaration. Lord Justice Phillips had also a slightly different view on that, again siding with the first instance judgment, because it found, as we said already, that the declaration more or less had the objective to influence the foreign proceedings. And this objective, in the view of Lord Justice Phillips, smacks of jurisdictional imperialism. So he used more or less the same term as well as we've seen in the first instance judgment. So the question then was, if there is an obligation or a willing licensor would grant an interim license here, what would be the terms of this interim license? Because just for us to remember here, or at that point in time, we had no FRANT determination. The hearings hadn't even started before the High Court in first instance. So here there was, of course, a debate: should it be should the interim license be based on the terms that Panasonic offered or the terms that Xiaomi had counter-offered? And the court said here, well, neither is necessarily the case, because the court is as capable of determining the terms for the interim license as it is for the terms of the final license. Of course, you cannot have the same level of scrutiny. And of course, at that time, we didn't have even the first instance court dealing with what would be the FRANT terms here. But the court said, if we can basically determine the final license, then we have also the ability to determine the terms of the interim license. We don't need to pick between the offer of the patent owner or the counter offer of the implementer. Interestingly here, Lord Justice Phillips had some concerns, because he found no support for the view that English courts have jurisdiction also to set the interim FRANT prior to the final FRANT determination. So there is, of course, case law. The UK Supreme Court has confirmed this, that the English courts can make a final FRANT determination, but whether they have jurisdiction to do this interim FRANT determination in the sense of setting the terms for an interim license was not clear in the eyes of Lord Justice Phillips, and it was more or less a question that was what was open. Anyhow, the Court of Appeal decided then to say also what would be the terms of the interim license, and it basically said that it should be the terms offered by Panasonic for the final license with two modifications. One modification would be the term. So Panasonic offered a license for the period between 2011, which was the start of use by Xiaomi, until 2029. But the court said here the interim license should be until we have the FRANT determination by the UK court. And since we didn't know when this would happen, the court took just the 31st of December 2024 as the end point. And the second adjustment was about the sum. So what would be the sum that should be paid here? The court took the midway between Xiaomi's offer and Panasonic's revised lower offer and made an adjustment pro rata. So this would be the terms that the willing licensor in the position of Panasonic would have granted, agreed to enter into with Xiaomi pending the final determination by the court in the UK. Finally, there was one debate which is also interesting and not really related to the specific case here, meaning that it was not crucial with respect to the conditions under which this declaration should be granted or not, but it was a very related discussion which the court had with the parties here. And it is a discussion around whether this application, this motion to have an interim license, at the end of the day results in an anti-suit injunction. An anti-suit injunction, just to refresh our memory, is a court order which prevents a party from starting or from proceedings with or progressing with proceedings, court proceedings in another jurisdiction until the court that grants the anti-suit injunction, the ASI, has decided the case. So here, the Court of Appeal found that the motion of Xiaomi does not result in an anti-suit injunction because it's obviously not an application for an anti-suit injunction. It is an application for a declaration, as we've seen already. And in effect, the Court of Appeal found that it does not amount to an anti-suit relief by the back door. In contrast with another case, the Lenovo Ericsson case, where the court had found that a similar application for an interim license was an anti-suit relief by the back door. So why did we have this? Was this motion not an anti-suit injunction? The court said here there are two reasons for that. There are differences in the negative sense because Panasonic would not be prevented from pursuing the firm proceedings if the declarations sought by Xiaomi would be made. We said that already. So there are those declarations that don't have, let's say, an order. They're not an order to stop the proceedings. But also in the positive sense, there is a difference between these declarations here and an ASI because they, according to the Court of Appeal, help to regulate the commercial position of the parties pending the front determination. They would give access to substantial royalties to Panasonic, in contrast to an ASI, which would not have any payments as a content. And then the declarations were considered less intrusive than an ASI and designed to promote the overall resolution of the dispute. So basically, the court saying it's not about an ASI by the backdoor here because you have real effects and you can have support to the resolution of the dispute here. One final comment was that Lord Justice Phillips had a different view here as well. He did not contest that Panasonic did not act in a proper way, so he agreed with the other judges on this one, but it found that the actual relief here, these declarations, were not the right relief. He rather had supported the view of granting an anti-suit injunction here because he said if you look at the case, you could very well argue that the conditions for granting an ISI would be given here. So there was also, from this point of view, some different views from Lord Justice Phillips as whether the declarations are the right relief here or whether an ISI, which would be indeed an ASI, not from the backdoor, but indeed an ASI, an original ASI, would be more proper in these proceedings. So this was the decision here. As we said already, this judgment was granted. We did not have any interim license granted by the parties. And this is probably also not a question anymore or an issue anymore because the parties have settled in the meantime.